My name is Alina Shaltsova. I'm an immigration attorney from Brooklyn, New York. In today's live Facebook presentation, I would like to tell you about 4 common mistakes when one is answering Notice to Appear. Notice to Appear is a document that starts removal or deportation proceedings against a person in United States Immigration Court. Sometimes it is served by person, meaning that it's given to you. Sometimes it is mailed to you, but regardless, there will be a time when you have to appear in court. I hope you will appear in court and answer the allegations against you. Allegations contained in Notice to Appear usually look something like this. Your name and so, your name appears at the top left corner. Then there is your A number, and then there are allegations. You so-and-so entered the you are not a citizen or national of the United States. You entered the United States on such and such date, or on unknown date and time and place. You remained in the United States past your authorization. Maybe you didn't have authorization to enter the United States. And then there are specifications of further charges against you. Perhaps the notice states that you committed or admitted to committing a certain crime. And then there may be a second page to it explaining what grounds of inadmissibility or deportability are asserted against you. So what mistakes people usually make when they handle that? And this is handled during the master hearing, that small immigration court that you would go hopefully with your attorney. Well, the first mistake, if a person admits entering the United States or coming to the United States on the wrong date, okay, and year. Sometimes the year and date makes all the difference in the world. If you made a mistake, and let's say you forgot when you entered, or you didn't talk to your lawyer about that before, and you stated that you entered on the wrong year, in the wrong year, it may disqualify you potentially from relief, because the length of time in the United States may matter. Also, it may matter as to if you passed your 1 year to file asylum, because asylum deadline is calculated from the date of your entry or not. So it's very important to review those allegations with your attorney and not to admit to it if you believe it's the wrong information. And at times you will have to prove that you entered not on the day and time and place that the government says you will have to. It depends on which proceedings you're in, but review that point. It's very important. Second, admitting the manner of entry. One of the allegations is going to say how exactly you entered, without inspection, all right, or maybe on a visa waiver, or maybe with a visa. It's very important to review that allegation if it's contained in a Notice to Appear, because visa waiver, admitting to the visa waiver entry, will probably disqualify you for many forms of relief, because when you sign that visa waiver, you waive your rights, okay, to the hearing. It will largely depend on the prosecutor if they want to do something about it or not, okay? Also, sometimes a person is entering the United States and actually is inspected and admitted, but does not have documents to prove that it happened. All right, so that's very important to, again, review with your attorney and see that that allegation is accurate. Let's move on. What other things can make a problem? Not usually admitting that you're removable based on certain conviction, the way you're removable that the government says. Very often, the government will say that the conviction that you unfortunately received, let's say, is a crime of moral turpitude, and it disqualifies you from certain immigration reliefs. So if you would like to contest that, you have to state that in your allegations. At times, the government will say that it's a drug trafficking offense. Also, may be arguable if that offense is drug trafficking or not. The same goes for aggravated felony. Aggravated felony especially. Not every crime that sounds really bad is an aggravated felony. Not every crime that sounds not so bad may not be an aggravated felony. It's actually a very interesting area of law that you need to be aware of, and every time you're dealing with the criminal convictions, if there are allegations of criminal conduct against you, you need to have an attorney, because not even all lawyers or judges agree which offense constitutes, let's say, crime of moral turpitude. You can Google real quick and you will see that there are many decisions about the same statute, and different courts will say different things. One judge is going to say it is, and another judge is going to say it's not. And for you, it may make all the difference in the world. Okay. So, and last mistake that people may make is when they forget, or they do not know, or they're not prepared to state all forms of relief they will be applying. Because strictly speaking, if you forget to state something, you may be found that you waived your rights to it. Waived meaning you gave it up. It's very important to sit down with your attorney and talk about all possible things you may qualify for, okay, at the master hearing, and state that. It's very, very important. So these are the tips for answering notice to appear. I hope you will have a lawyer who will help you, and a good lawyer. But if you circumstances are such that you need to represent yourself, these tips may be helpful to you. And of course, you will have to prepare, read more about it, because this is just the beginning of the analysis. All right, never rely just on one article that you read online. You really have to do your research if you decided that you have to represent yourself. Okay, you can read more information about immigration law, analysis, different tips on our website, www.shaltsova.com. Thank you.